I am Ambarish and I am a partner with Shardul Amarchand Mangaldas and Company. I am here to talk about the impact of business disruptions caused by novel coronavirus or COVID-19 on commercial contracts. The question that we get asked often is, are these grounds good enough reason for suspending obligations under a contract? The answer to this question depends on several factors, the most important of which is the contract itself. There are two possibilities. First, the contract itself contemplates a situation like COVID-19. This could be through a force majeure clause or a material adverse change or MAC clause. The second possibility is that the contract does not contemplate a situation like COVID-19, in which case the principles of frustration of a contract under the Indian Contract Act 1872 may apply. Let's start with force majeure first. Force majeure is French for a superior force. In order to invoke a force majeure protection, two important conditions are required to be satisfied. First, the contract must contain a force majeure clause, and second, the scope of force majeure clause in the contract should cover the business disruption caused by COVID-19. Let's take an example. If the force majeure clause in the contract specifically contains reference to an epidemic or a pandemic, it is easier to claim that the situation caused by COVID-19 is a force majeure event. However, if the force majeure clause in the contract does not refer to an epidemic or a pandemic, but generally refers to an act of God, in that case, it becomes a matter of interpretation of contract to find out if the parties intended for a situation like COVID-19 to be covered within act of God. If both of these requirements are met, that is, the contract contains a force majeure clause and the force majeure clause is applicable to the situation, the next important step is to follow the contract and the provisions related to force majeure strictly. This may include sending appropriate notices, following the process specified in the contract for delivery of notices within the specified timelines. This is an important step to preserve your right to invoke force majeure and seek protection. Another typical clause that could be relevant to a situation like COVID-19 is MAC, or material adverse change. Typically, a contract would provide what constitutes MAC. And if COVID-19 falls within the category of MAC in a contract, then the MAC clause could also be invoked. Typical consequences of there being a MAC in a contract include the ability to terminate a contract or the ability to claim indemnity if there are representations and warranties with respect to MAC. If a contract does not contain any of these provisions, for example, the contract does not have a force majeure clause or the contract does not have a MAC clause, in that case, the principles of frustration of contract under the Indian Contract Act become relevant. The doctrine of frustration is contained in section 56 of the Indian Contract Act, and it provides that a contract could become void if it is impossible to perform such contract or it becomes illegal to perform such contract. The standards under section 56 are quite high, which means that if a contract becomes impossible for a party to perform because of prohibitive costs or because it is onerous for that party to perform that contract, such commercial considerations may not meet the test of impossibility. Frustration, because of its high threshold and the legal requirements for section 56 to apply, is a matter of construction of contract. And whether or not a contract could be said to be frustrated depends on several factors, including the terms of the contract, the object of the contract, the intention of the parties, and the circumstances in which such contract was executed. Accordingly, it is relevant to review the terms of the contract and also the surrounding circumstances in which the contract was executed to ascertain if the contract could be said to be frustrated under Section 56. To summarize, there are three takeaways. First, it is recommended to review all your contracts to ascertain if they contain provisions that are relevant to COVID-19, such as force majeure or material adverse change, or any other provision which deals with a situation like this. Second, it is recommended to follow the contract terms with respect to notices and other provisions, and if notices are required to be sent, to duly issue those notices. And third is to seek appropriate legal advice. This video is intended to be for general information only and does not constitute legal advice. Thank you for your time.